National Security Minister Dr. Horace Chang has opened a debate on new provisions in the Criminal Justice Suppression of Criminal Organisations Amendment Act 2021. If approved, people who attempt to derail criminal investigations by falsifying, concealing, destroying, or disposing of documents or items relevant to a probe could face up to 10 years in prison. Dr. Chang was speaking in Parliament on Wednesday. If you are found guilty of these offences, you could be fined $5 million or experience a maximum sentence of 5 to 10 years if tried in parish or circuit courts, respectively. Clause 14 of the bill, which seeks to amend the Criminal Justice Administration Act to include a Section 39A, introduces the offence of tipping off
and establishes the circumstances within which a person would not have been found to have committed the offence. A person commits the offence if knowing or having reasonable grounds to believe that an investigation is being conducted or about to be conducted in respect of any offence. Under any law, he discloses information relating to the investigation to another person.
Discussing the latest statistics from the Jamaica Constabulary Force, Dr. Chang says there are 262 active gangs, a number of which forces underage Jamaicans into criminal activities.
Clause 9's amendment to Section 15 of the Principal Act, Offences and Penalties. As agreed at the Joint Select Committee, Section 15, Offences and Penalties, second schedule, is amended as subsection 2 by expanding the list of aggravating factors that should be considered at the point of sentencing a person for the commission of offence under the Act. Some of these aggravating factors include, in an offence under Section 4, which is the offence of recruitment of a child to a criminal organisation.
According to Dr. Chang, the amendment of the bill will also see changes to the Jamaica Constabulary Act relating to search warrants.
The Constabulary Force Act has been consequentially amended to include a new Section 17A to allow for the application to a Justice of the Peace for a warrant authorizing a search of a building, receptacle or place specified in the warrant, and seizure of any item specified in such warrant. The Constabulary Force Act is also amended in Section 2 by inserting definitions for the terms conveyance and vessel. In light of their usage in the new Section 17A, it is deemed necessary to define the terms to set the context in which they are intended to be used. It should be noted that the Joint Select Committee report prescribed that only a constable named in a warrant could give effect to the warrant. It was subsequently recommended, however, that this limitation be removed as it may pose operational challenges to the work of the JCF. There may be instances where the constable named in the warrant cannot give effect to the warrant. In such a case, the function of the JCF would be hindered. Additionally, it is noted that in practice, the constable is not named in the warrant. In light of this, the prescription has been removed from the reformulated provision. The new 17A(6) provides that where a constable seizes anything under this section, he shall, as soon as reasonably practicable, if satisfied that there is a dispute as to the person lawfully entitled to the possession of the thing, apply to a judge of a parish court for an order under subsection A, subsection 8A or C.
The National Security Minister says 61% of annual killings were assessed to be gang-related. Minister Chang says the legislation will provide an additional game-changing tool to the security forces in combating criminal gangs.